appreciate everyone coming out today. We're so excited to have Ed Smith, estate attorney and partner out in Florida, joining Sean and I with Bolt Financial Group to do a live Q&A, just really about estate planning, wills, all your questions answered. So typically, when we meet with clients first quarter, we talk about estate planning. So Sean and Ed are going to go through some scenarios and some issues that we see when we have these conversations, and things to look out for, things that you may have questions as well. So before I have Ed and Sean jump in, I just want to run through. We'll have some poll questions here just to get an idea of kind of where everyone's at. And then we also have a Q&A button at the bottom of your screen. So this is for you. Again, we'll run through some scenarios we see, but this is for you. Ask your questions. We want to make sure that we get those answered, especially that we have an expert on here as well. And so you'll see a Q&A at the bottom. Those are anonymous, so you can just type those in and we'll go through those at the end. And so with that, Sean and Ed, you want to jump in?
Awesome. Yeah, thanks so much, Nora. So this is special for me. Ed and I were student council president and vice president back at St. Ed's.
Oh boy.
So I remember the day he asked me to be his vice president, and I was like, yeah, absolutely. So special that we've come this far in a couple of decades. But yeah, what a great opportunity. Ed is an attorney, an estate planning attorney down in the state of Florida. So one thing we want to let everyone know is this is educational. This is not meant to be legal advice. This is not financial planning advice. With all things, please consult your own attorney, your own financial planner before you make any decisions. This is certainly going to be extremely educational for you, though, right? So we want to get your questions answered. Sometimes, though, we've had those very specific questions, right? My aunt passed away, and I'm going through this situation. Again, probably be a better question to kind of talk to your own attorney, but we want to make sure that we get kind of general overarching questions answered. If you do have those specific questions, please type them in there. We'll try to get back to you, or at least we'll frame it so that it can be known for all kind of participants rather than maybe your exact situation, right? So the way that we want to kind of handle this is we are going to be going through and are currently going through the largest wealth transformation in the history of the world. So starting in the 1970s, that kind of the inflation in the 1970s led to a change in the way that retirement plans were kind of carried out. So it used to be you worked till you're 65, you get a pension. Whenever you passed away, whatever money was left in there went back to the pension. In the 70s, 401ks and IRAs were born. So now people had the responsibility to invest for their own retirement. Well, those baby boomers that started working in the 70s are starting to pass away and starting to go through the process of leaving money behind. So for the first time in the history of the world, we're having hundreds and sometimes millions of dollars be passed down to other generations. And we combine that with kind of the typical estate planning concerns and processes. So what we want you to do is, typically we receive these kinds of questions when a client comes in and they're dealing with it with their own parents, or their parents just passed away and they say, I really liked it that mom and dad had X set up, or I wish they would have had X set up. How can I help myself? And so we're going to run through a scenario where we walk through what would you do should your parents pass away, and let's say they had a will set up. Let's say they had their accounts titled correctly, and maybe they had a trust set up. So we're going to walk through each one of those scenarios that you can kind of think about how this would play out in your own family, or how you want it to play out for your own children. And please ask questions along the way. So I think I like to start with, let's just say my parents just passed away. They've got kind of a typical account where they've got a 401k or an IRA. Maybe they've got some money in a checking and savings account. They own their home. And let's say they haven't done any estate planning at all. What kind of things happen following parents passing away? And then how does an estate attorney or someone come in to kind of help them through that scenario?
Yeah, thanks, Sean. First and foremost, as you want to analyze is, do we have one parent passing away, or do we have two parents passing away? Is a simultaneous death passing? That's pretty unusual, but let's play it the more kind of usual route, that maybe you have a husband and wife up in their years, maybe 3 kids married, maybe one child's going through a divorce, one child has a special needs, and one child owns a business, right? You see different kind of scenarios that go in with that. But when you walk in, we're always going to be waiting on a woman, says Brad Paisley. So let's say the husband passes first and he's in heaven waiting on a woman. So we have a surviving spouse coming into play. The wife is going to walk into our stateroom and say, what the heck do I do? Usually they're accompanied by a child, just because it's one of the, biggest rattle of their lives. And so, sometimes 40, 50 years of marriage, and now it's, what do we do? And so I guess there's definitely a human element to this, but at the end of the day, advisors are here to say, here's our best fact, right? This is what we can do, and this is how we can help. The vast majority of assets are going to go through probate under Florida, unless, so remember these kind of three things. This is only under Florida, it's not really legal advice, but everything goes through probate in Florida, unless the asset is, number one, jointly owned. Number two, the asset is beneficiary designated or pay on death. Or number three, the asset is funded into a trust. Well, let's break those down to give some context. So husband and wife own a piece of real estate jointly. Husband passes away. Usually that property is owned, let's call it tenants by the entirety, or maybe joint tenants will write a survivorship. At that point, by operation of law, that property immediately goes to surviving spouse, at which point that property is owned by the surviving spouse. Great, nothing to do, right? Well, we'll get to that in a minute. Number two, beneficiary designations. You have a husband, you have a wife, husband passes away, and he has an IRA, a 401k, or life insurance directed to the surviving spouse. Well, that goes right to the surviving spouse. Nothing to do, right? Well, no, there's some more planning that goes into that. And then number three, if you don't have a trust, it's something to consider. A trust is nothing more than this. Think of it as a bucket that holds your assets. All of these pens and pencils represent brokerage account, real estate, business interests, gold, silver, LLC, all right here. The bucket is really the trust. You are the trustee during your life, the bucket holder. You have beneficiaries, which are namely you and your spouse during your life. And when you pass away, the lid goes on the cookie jar. The surviving spouse reads the babysitter instructions and says, while I'm gone, this is what's to occur. And then when that survivor passes away, this pours out into probably three little mini buckets for the benefit of the kids. So we'll get to a little bit of that. So in Florida, under law, everything goes through probate, unless number one, it's jointly held. Number two, it's beneficiary designated, pay on death. Or number three, it's funded into a trust. Okay.
Yeah. So, and let me ask you a question. Let's say we pass away. We don't have any of that done. So everything's going to go to probate. My parents just passed. How long till I go to probate? What do I have to do to even get into probate?
Yep.
How do I say, hey, government, hey, court system, my parents passed away. I need a court date. And then let's say we've got those three siblings. Who's the one going to court? What if my siblings live out of state? How does that whole process work with probate?
Sure. So before we get into how do we get into probate? What is probate? All probate is simply a court supervised, so the court's overwatching, distribution of your assets that you owned at your date of death that were not under category 1, 2, or 3. So what doesn't fall under category 1, 2, 3? Let's say this pen represents a brokerage account to the tune of $600,000. It was not jointly owned. It did not have a beneficiary, and it was never funded into a trust. Husband passes away. Who owns this pen? And why can't I just go and claim it? Why can't Jimmy Johnson go and claim it? That's the probate process. It's saying, okay, our husband passed away, Jimmy Johnson. How do we walk this through? So what you would have is you pass away either with a will, which is called testate, or without a will, which is called intestate. If you don't have a will or a trust or anything, don't worry, the great state of wherever you live has it prescribed in the statute, and they indicate who gets what and how. So that's why it's kind of an important aspect of, why would I want an estate plan, or why is it so important? Traditionally, intestate without a will goes to the spouse, if not to the spouse, to the kids, if not to the kids, up to the parents, if not to the parents, out to the siblings. So that's all fine. Why do I even need a estate plan? Well, because are you concerned about remarriage for your spouse, and then it goes to the pool boy or tiki girl? I mean, that's a concern, right? If they get remarried. Or let's say, it goes right down the line to the kids. Well, remember we just talked about the 3 kids? One's going through a divorce, so now that idiot son-in-law is going to get half, right, of the distribution. One child has special needs, which need a special kind of trust. And if they receive an inheritance, now they're disqualified from Medicaid and their public benefit. And then one owns a business, but he just got sued and has a creditor issue. So that's why you want kind of estate planning in place to cover all those contingencies. Does that answer the question, Sean?
It does. So let's say that brokerage account, right, is being walked through. If my spouse passes away with an individual brokerage account, I'm not able to just go to Sean or to the bank and say, hey, I want those assets. How does that account get to probate? How do I get a probate date? How long does that process take? What is kind of the next steps from there?
Yeah, I mean, what you need is, so the great state of Florida indicated that a personal representative, which is synonymous with an executor or executrix, 6 1/2 dozen, that personal representative cannot walk the assets through the court system. They need to retain an attorney. You know who wrote that statute? Attorneys. So, and there's good reason, right? Because there's a lot of complexity to it, and otherwise, who's going to get the pen? So we have a lot of clients daily come in that say, hey, I lost my spouse, lost my father. And so what they do is they retain our services, and we basically charter the ship for them, right? It's their boat, it's their cargo. We're just acting as captain to bring it safely across to the other port. And really what you're looking at is probably like a 9-month process.
Wow.
And what you need is you need letters of administration or testamentary letters. And so that indicate maybe a month or two into the process that the personal representative or executor basically steps into the shoes of the decedent. And now they can handle the accounts, do what needs to be done. And with that, you open up estate accounts, fund that pen into the estate account. And if you're doing probate, you need to pay the creditors first. You have a $600,000 brokerage account. Dad had a $30,000 debt outstanding that's valid. You got to pay that $30,000, and whatever white meat's left over is going to get distributed to the wife, beneficiary, or whoever the family is.
So if I rack up all sorts of credit card debt, it doesn't just go away when I pass away. That's not.
Lauren would not like that. Don't do that.
Yeah. So no, that's great, right? So the first thing you should do is contact an estate attorney to help walk you through that process. It sounds like if you haven't done nothing, that asset must go through probate. So what we'll see a lot of times is when we talk to people is we'll ask them, do you have an estate plan? They say, yes, I have a will. So now they have a will. Do they still have to go to probate?
Yeah, common misconception. All wills, all is a very powerful statement, but the vast majority of wills go through probate. That's exactly what a will does. A will is, remember, the testate provisions determining who's getting what in your probate. If you don't have a will, then you have an intestate proceeding, where the great state of wherever you live determines who gets what. So think of it as 2 tracks on a train. A will goes through probate, and a trust goes through trust administration. A will has personal representatives or executors. A trust has trustees. Those are the quarterbacks, I guess you'd say. So next is, well, how long does it take? Probate takes in Florida about 9 months. Trust administration, about 2 months, 3 months. How much does it cost to go through probate? Depends, but a presumed reasonable fee is 3%. So $1 million estate, $30,000. How much does it cost to do a trust admin in Florida? Well, presumed reasonable fee, about 1.5%. So you cut your expenses in half on the back end. So that's a big thing. So time and money. Life is all about time and money. And so, you know, sometimes money can buy time, but at the end of the day, estate plans can also buy.
Yeah. So let's say I've got that will. Before, when I was intestate, didn't have a will, I needed to contact you to help me walk through it. If I get a will set up, do I then not need an attorney? Do I just go through probate on my own with that will? What's that process look like?
Unfortunately for the client, it's pretty much the same process. Intestate without a will, there's a couple more loops and hoops to jump through. Testate with a will, maybe a little bit more succinct, but all of them are going to go through the courts, going to go through the probate process in Florida. So that's why trusts are such a, I guess you'd call the bishop in chess, right? They can cut through a lot of different things.
Yeah. And I think that's one of the things that we as a common misconception. Do you have an estate plan? Yes, I have a will. They don't realize that guarantees court involvement. A will must go through court, and therefore they're still going to have to retain your services to be able to go through that process. So typically the whole point of estate planning is, how do I avoid that court? How do I avoid probate? And there's kind of a couple of different strategies, right? You can title assets, you can put assets in a trust. Let's say that all of my accounts I did by titling the assets correctly, meaning On all my IRAs, 401ks, I had a beneficiary. Rather than that brokerage account being individual, it was a joint account. Or maybe I had a transfer on death for that checking savings account or that brokerage account. How do I then get those assets? Do I still need your services? Do I still have to go through probate? What happens if I just put a beneficiary on all of my accounts? How does that process look different, for my after I pass away?
Sure. So I'm a trained skeptic and cynic, and I call that akin to quasi-hillbilly estate planning, right? Because, and I say that jokingly, tongue in cheek, there's plenty of things that I have done that are maybe not all the way through. But at the end of the day, it really comes down to awareness. If you're not aware of the issues that can come down the road, then you're going to just address that issue and say, hey, I got a beneficiary, it's all set. Or even better, hey, I have a house, I'm a single surviving spouse, I have 2 children, I'm just going to put them on my house jointly, so that way last man standing gets the property. Well, once again, what happens if they go through a divorce and that's subject to a divorce proceeding? What happens if they have a creditor issue or a lawsuit? That exposes your assets. So, I mean, if you want to talk a little bit about asset protection, by putting other people's name on your property, you expose yourself and kind of shoot yourself in the foot with regard to asset protection. So when you're saying, well, hey, if I just put a beneficiary on these accounts, right, call it a 401k, IRA, maybe I can just put my 3 kids on it. You have a sole surviving spouse, let's put the 3 kids on. That's fine and generally acceptable, assuming that we're aware of what can occur, right? And that's really when it becomes fact specific. And that's where advisors like you, Sean, advisors like myself, CPAs would say, okay, tell me the story of your family, because the numbers are the same. It's a 401k account, it's a life insurance brokerage, a trust is a trust, a will is a will, but the stories and the characters are going to reflect what you need to do. Because if someone says, yeah, my son has issues with drug or alcohol, yeah, my daughter's marriage is a little bit on the rocks, well, then maybe we don't want to make him a 1/3 outright beneficiary on $1 million IRA. Maybe we don't want to make her a 1/3 beneficiary outright, right, on $1 million IRA, because what happens? You pass away, that $333,000 goes directly to your son who has a drug or alcohol issue, or that goes directly to your daughter, $333,000 with the marriage that's maybe on the rocks, and he could have seen it coming. Then he files for divorce, you've passed away, and he gets half. So there's good, better, and best, right? So that's good. Better would be to maybe have it disposed into a trust, and then best would be have it disposed into a trust with a lot of shrink wrap around here saying, when I pass away, you may receive the assets subject to these provisions to protect from drug or alcohol, spendthrift provisions, creditor issues, divorce. That's a good, better, best approach.
Yeah. So let's say my parents, right, just passed away. They've got money in a brokerage account, right? They've got money in the 401k, IRA. They've got a house, right? So, or let's say I had just one parent left at this point, and that house was owned by them wholly. There was no trust on the house. They didn't have a transfer on death on the house. The 401k, I was the sole beneficiary, and my brokerage account, they had a transfer on death to me. So do those assets need to go through probate? Which assets do need to go through probate? And what are maybe some stories that you've seen happen if, hey, I really, really trust my son. It's fine if he gets the assets right now. I don't need to put any provisions on it. I just want to get him that money as quickly as possible. So talk to us. Do those things still need to go through probate, or which ones do? And then what are some stories that maybe you've seen where I didn't think about that happening, and now I see the value of maybe not just titling my assets correctly as my estate plan.
So this is where, Sean and company come into play, because you have a surviving spouse who has an inherited IRA or spousal rollover, whatever it might be, and there's $1.7 million sitting in that account. But there was no contingent beneficiary listed on that account. So it's all from dad to mom, or mom to dad. At which point that account, the surviving spouse passes years away. They never updated the beneficiary designation. So remember, prong 1, jointly owned, prong 2, beneficiary or pay on death, prong 3, funded into a trust. That would have escaped probate under prong 2, because that asset is going to be beneficiary designated. We had a client walk in after the planning, of course, and said, hey, mom, dad just passed away at a $1.7 million IRA. No problem. Let's make sure we get on the horn with a financial advisor, and then we'll make distributions pursuant to that. they didn't update the beneficiary designations. So now you have a $1.7 million IRA that could have avoided that 9-month probate process, right? To the tune of 3% on that, $50,000. Then now they have to wait to get their distribution on that. So it's one little, small hinges swing big doors. So you got to be mindful of those details right there. So that's like one item that I would recall.
And let's say that they did. Let's say mom had passed away. They asked her with the dad. Dad had passed away, but dad updated it and put child on there as a beneficiary. Does that asset still have to go through probate? How does that kind of change?
Nope, changes the game entirely, right? Goes to Christmas past, present, and future. Marley'd be visiting you there because you'd be like, God, I wish I would have done that, right? At the end of the day, you know what would happen? You walk into Sean's office with a death certificate. They set up, 2 brokerage accounts for you and your spouse. They deposit the asset in and you're done. 2 weeks.
Yep. So much quicker to do it that way, right? So it avoids probate. You don't have to have the will set up. It happens immediately. But, right, I'm married and maybe going through a divorce. Now, those assets could potentially go to ex-spouse, something like that. Or what are some other stories and reasons that maybe titling the assets alone would not be the best situation for an estate plan?
Yeah, we had a husband and wife owning a $1.5 million property down here in Florida, and it's homestead property. So Florida homestead has a complete uniqueness to it, so I don't want to really get too deep into that, but there's a couple different ways you can own property. Sean and I can own a property jointly. We'll write a survivorship, meaning I pass, it immediately goes to him. Or Sean and I can own a property jointly, 1/2 interest. So you got to be mindful of that. And then there's a way that you just own the property individually. This is kind of unique in that you had a husband and wife owning the property jointly, and they put a daughter's name on the property. Thought, hey, I wanted to give her a specific devise right when I pass away. I have 2 other children that are taken care of. My one child that I added onto the joint property, she didn't have any kids, and we helped out with the grandkids' college. So I want this to go right to her. So they come into our office a day late and a dollar short because there was a creditor issue with regards to her asset. So her name was attached to that property. And so if you own property between husband and wife in Florida, it tends by the entirety, it's creditor protected. But since you have a third party on there, it kind of severs that so that you have an interest now that's subject to creditor claims. So that's a big issue. What we could have done instead, have a trust in place. Let this property represent the homestead $1.5 million property. Fund it into the trust. Husband and wife still own it, use it for the rest of their life. And then there's just a direction on there saying, when we pass away, daughter gets this property first. Boop, it's called specific distribution. And then the rest, residue and remainder, a third. Right?
Yeah.
Those are a couple issues.
Yeah. And so how does that change if I've got like a brokerage account versus an IRA or a house? Let's say I have a brokerage account. I've got it titled so that it goes transfer on death. Now all of a sudden that same $1 million account goes to my child. My child, is there any stipulations on that? Or what happens if they get divorced? Or what happens if they do have kind of some creditors coming after them? I just gave them some money. Now what happens?
You're exposed. You've exposed yourself. So, there's Russian dolls. I think they're Mariska dolls that you pull the one off and they get smaller and smaller and smaller. That's all trust planning is, right? You have the big trust that breaks down into the spousal trust, that breaks down into the kids' trust, breaks down into the grandkids' trusts. And that's called kind of dynasty generation planning so that your assets will flow pursuant to that. Otherwise, if it's just an outright beneficiary designation, you're exposing yourself. And there's a lot of things. I mean, I think, Sean, we were briefly talking, another hypothetical or actually a real client issue is owning real estate. Oftentimes, real estate is one of the largest assets, aside from an IRA or 401k that a client owns, maybe a business owner separate. If you own a condo in Florida, a home in Florida, and you are domiciled in Ohio, Pennsylvania, wherever it is, you better make sure that that asset's not individually owned. Because here's the downfall of that. If you have an asset that's individually owned in Florida and you live in Ohio, let's say, and your husband passes, now you're a sole spouse. If you don't title those assets properly and you pass away, your kids will now have the pleasure of doing probate in Florida and a probate in Ohio. So a way around that, or a really effective planning tool, is to say, well, this property that is owned outside of the state of where I reside, right, is individually owned. What I'm going to do is get an attorney licensed in that state to deed the property from Sally to the trust of Sally. Sally passes away. We've avoided probate in that state. Now we're only doing one trust administration in the estate in which we reside. So if you own real estate in a couple different states, and a lot of people Air Force based, or maybe buy a property, keep it as a lease or a rental property, you might want to look at that.
Yeah, that's great. So far, right? Parents passed away. If they don't have a will, goes through probate. I've got to contact an attorney to help me get through that process. Let's say I've done a will, which a lot of people think that that's the proper estate planning. They still have to go to court. They still have to contact an attorney to help them walk through that process.
Yep.
They could tell their assets correctly, but then it's going to go to that child immediately, or the beneficiary immediately. And then if there are creditor problems, if there's a divorce, something like that going on, that money is subject to all that kind of liability.
Mhm.
Let's say I want to avoid all of that. What would be the next best option, and how do I go about that process?
Sure. The best option would be to meet with an attorney licensed in your state that's qualified. What does that even mean? Well, it means someone, if I have a heart issue, I don't go to the podiatrist, right? You don't want to go to someone that does criminal defense, family law, and estate planning. It's like, well, you want a specialist in these areas. Go to that person, meet, and what you do is a chart of accounts, right? Here's what we own. Here's how it's titled. Here's the beneficiary, if it exists. Here's the amount. And then here's the purchase price that we created, because you want to get tax efficient too. Then you meet with that individual, and then you have a come to Jesus talk and saying, here are my 3 kids. Everything good? Yeah, everything's good. Yeah. Any issues? No, they all get along. Nobody threw Thanksgiving turkey at each other? No. Well, and then you dive a little deeper and deeper. Then you realize maybe one of the in-laws they don't like, and maybe one's got a business that's not doing as well, and maybe one's got, so you find out all these issues and say, all right, here's how we're going to protect along with regards to this. And you create that trust. Well, trust in between 2 people, but also the revocable trust. And you can change and do whatever you need to do with this trust. And then you plan it out saying, when I pass away, I want this to go to my spouse. When the other spouse passes, to my spouse. And they both pass down the line to the kids, but not outright, maybe in trust for their benefit. And then the terms of that trust indicate who gets what and how.
Yeah. So you put assets into that trust. What are some downfalls if someone does like something through like a LegalZoom, right? They say, hey, I can get a trust done on LegalZoom for $75. I've got this piece of paper. I'm all set.
You know what's interesting? Penny wise, pound foolish. I've had, $20 million clients come in with LegalZoom doc. I'm like, what are you doing? But hey, what's interesting too is if they did not do that, if they did nothing, it would be better than having done a LegalZoom that's wrong. I know it's weird, but it's really true. You're completely allowed to do that, but I would caution you. Similarly, I don't do my own plumbing. I tried it once. So you go to the specialist to make that happen. The cautions that you would do, simply executing the documents. There's been documents in place that have not been notarized. Moot, gone, don't exist. Right? I mean, it could be something as simple as that without having proper witnessing and notarization. The document fails. Nobody can attest to it. So that, great document that you did that you thought made everything go properly blows up, not even on the terms of the document, but just on the actual execution of the document. So that's one thing.
And how about another thing of I'll ask them, do you have a trust? And they say yes. And then I see the list of accounts and I ask who the beneficiary is, and there's either no beneficiary or it's still their child. And I'm like, I thought you had a trust. What are some kind of pitfalls with, hey, I went and saw Ed, I talked to Ed, everything's great. I've got this document, wonderful shiny folder, but what happens then?
Yeah, so I want you all to close your eyes and envision your most favorite beautiful car. And then realize that there are no tires on the automobile, because that's really what you're doing when you have let this represent a trust with no assets in it. Because now all you've done is created a beautiful document with shiny gloss paper, right? That has no tires. It doesn't go anywhere. So what you have to do is actually fund the trust. It's a huge issue. Sean runs into it, I guarantee. I do every day, because most attorneys do not fund the trust for the client. So if you do have a trust, a thing to ask yourself is it properly funded? And what does properly funded mean? That really depends on what the assets that you own are. Because if you have a trust, let's say this represents a trust that is not funded. See, no assets in it. What happens when you pass away? Well, unfortunately, you just double dipped your work. Let this represent a will. This is called a pour over will. All trusts have a will, and they're called pour over wills. When you pass away, if your trust does not have assets funded into it, and you have assets that fall subject to probate, this will needs to go through probate, and then it is poured over into your trust. And then the trust will disseminate the terms pursuant to whatever we have written. But that's a huge issue. You have, call it a $5-10 million estate. You have a beautiful trust, nothing's in it. $5-10 million probate to go into a $5-10 million trust administration. You've doubled your expense and your time.
Yeah.
So why do people do estate planning? It's more than to give what you have to who you want, of course, right? That's a scientific neutered event. To save on taxes, sure, that's important. What it is an act of love for your family, so that they don't have to do this when you pass away. Because it's hard enough to lose a loved one. And the last thing people want to do is, shuffle complex documents through court systems, right?
Yep.
So it's really an act of love.
Yeah, and I think it's unique, right? The funding the trust is client will have a trust document done, but they've never gone back and updated the beneficiaries, just like you said. And really, it comes down to, you can go to an attorney, get this document drafted up, but the attorney is not going to walk your hand into the bank and say, hey, did you get the TOD done? Did you put the transfer on death into your trust on your checking and savings account? Did you actually update your beneficiaries in your IRA to look at it and say, yes, now my primary beneficiary is my spouse, my secondary beneficiary is my trust? They don't have insight into all of that. So the power of working with a team, right, a state attorney, a financial advisor, a financial planner, can say, hey, we have communicated. I know that you have a trust, and we've gone through and we've reviewed all your accounts, and your beneficiaries are updated appropriately. That way, you can actually take your trust, make sure it's funded, and complete that processes of estate planning. So let's say I've got this trust set up, and I have a home. Every state's different. I know, like in Ohio, I believe you can do a transfer on death into a trust. I think we talked offline and said, yeah, not an option in Florida. So depending on where I have my property listed, I may or may not be able to do that by state law. Let's say I have my house and I've deeded it into my trust. After I pass away, let's say I pass away January 1st, are my children then allowed to go sell that house on January 2nd to get the assets? Or how does that process play out to say, all right, I did my actual trust planning. My parents have passed away. They did a trust. They had my accounts all titled correctly. Everything is going into the trust. Do I still need to contact Ed? Am I now able to do it on my own? What does that process look like?
Yeah, absolutely. So whenever someone passes, call the attorney, call the financial advisor, call a CPA. Because even if nothing needs to be done, guess what? Something has to be done. And if you're, once again, back to awareness, if you're unaware of an issue, right? If you're unaware that the key that you're locked in the room with is sitting under your chair, you're going to remain locked in there. So the whole idea is, if you have a property, January 1, they pass away, and can my kids sell the asset, the real estate? Well, it depends, right? Because who's in charge of this trust when everyone passes away? The trustee. Who's the trustee? Traditionally, it's a child or a group of children that are the trustee, but sometimes, call 20% of the time, it's an individual third party or financial institution to remove any of those issues. And that really depends on the family dynamics. We have 3 kids and one's going to feel, hurt since they threw sand at them in the playground when they were 5 and they're going to make a fight about it. I mean, that's a whole other ball of wax. So what happens is maybe you have an independent trustee, but at the end of the day, whoever is the trustee bucket holder will be able to list that property as trustee, sell the property to Billy Buyer, in exchange, receive money into the trust account, and make distributions pursuant to the terms of the trust.
So one of the common things is, do I have a trust account? Do I have an estate account? Do I need both accounts? As soon as I get that money, do I just go get rid of it? Or what are some things that are going to come back in terms of taxes and fees? And what are some things I need to play out over some time before I actually release those assets to my brother and sister, or whoever it may be, if I am the trustee? What are my responsibilities as a trustee? And
Yeah,
when can I
tons.
start to take action?
Tons, yes. I mean, you know, you got 100 slices of pie, but the estate, the probate estate or the trust estate, right? There's two different estates, have different numbers on those. You have a tax ID number for each. Really, you have a personal representative or executor has their own set of duties, and you have a trustee who has their own set of duties. Oftentimes, they're the same person. So let's just assume that they are right now. At that point, they're not like, you know, someone passes away January 5th. They're not cutting checks January 15th. There's a whole process that needs to go. And so sometimes you run into issues when you have a sibling that maybe needs the money or wants the money, and they need to just pump the brakes because you got 100 slices of pie. You got to make sure the creditors are paid, the attorneys are paid, and it's mainly creditors. Because if you have, you know, money in the account, but there's creditors of the estate, they have priority. And then attorneys and then beneficiaries all the way down the line. So it takes a little bit of time to make distributions, certainly from a probate estate, but definitely through a trust administration estate too.
So maybe I would open that estate account. I'd open that trust account and just say, hey, brothers and sisters, this is going to happen. It's going to take some time. What's a reasonable amount of time? What are some things that may change that time? Someone being in a different state, not being local, going through some problems. What are some ways that the trust would kind of, or a trustee should kind of make sure that that's played out correctly? And
Sure, you can do partial distributions too. So let's say everyone's getting kind of anxious. January 5th was the date of death. It's now Groundhog's Day. We have our ducks in a row, so let's do this. I'm going to make a partial distribution to everyone. But you know what the attorney's going to say? I want a waiver and consent and refund agreement. Basically saying you got a $5 million estate. Everyone's going to get 500 right now. But I'm going to have you sign this receipt indicating that, hey, if there's a creditor that comes out of the woodwork to make a claim and you already put, you know, $500,000 down on a Blue Ridge, Georgia mountain home, I'm going to need $500,000 back. So, I mean, it's a refund agreement that you would have if people are getting itchy. But yeah, trust administration making distributions within, I don't know, 6 to 8 weeks is pretty reasonable.
Okay. And then what if I have to sell the property, all that? I've got to go hire a real estate, a realtor, go through that process.
Sure.
Those assets come in. Do I put those in the trust estate account? What does all that look like?
Well, it depends, right? So let's say you have a decedent, Columbus, Ohio. They have their homestead property, call it, where they raised the kids and did their thing, right? But then they have that Florida property worth $1 million. The market is extremely high right now. You can get a consensus among the children on whether they want to sell or hold or lease or whatever it is. Let's say you got one that's coming out of New York City and says, I need to get out of the city every now and again. I want to purchase that $1 million property. No problem. Do you A, have the cash? Do you B, have a mortgage? Or do you C, take a reduction on your estate distribution? Now that's going to make sure that every 3 of the kids get along and play right. But there's ways to divvy things up. It's so long as there's not terms contrary to that in the trust. So, you know, this is big in UP, Michigan, Canada, basically cabin clauses, right? Those cabins that have been held in the generations and what they go to, those can get very touchy. And so, you know, if you're having a situation like that, better than put it into a trust is maybe create kind of a cabin agreement on it by an LLC and transfer that into the trust so that it determines who's getting what and how. Otherwise, you know, you have that or Shore Home on New Jersey. And, you know, Sean always gets July 4th every year. And someone's upset about that, right?
Yeah.
I'm stuck with Labor Day, right? Nobody wants it.
Yeah. So that's neat. You'd have an agreement that would kind of go into there and that would now play it all out. And you could write that up as mom and dad while you're alive so that you just kind of dictate the agreement right there. What happens if a child, right? Say there is a property, right? There's that property down in Florida, beautiful Naples. And one of the kids wants to keep using it as the vacation house. One of the kids wants to sell it and the other one wants to lease it out. What happens then if it's not specifically laid out in the trust? Mom and dad didn't think about that. They just said, yeah, house goes into the trust. You guys figure it out. How does that delay the process or what happens then?
Not great lawyering at that point because the trust should have provision indicating what's going to happen. Most often, more often than not, property is liquidated and distributed unless the kids can come to an agreement about who's going to purchase it. Because if one wants to keep it and one wants to lease it out, those are kind of your big ones. Because the other one, the third little pig, right, is going to get what they want, the money, whether they come to an agreement on leasing it or whether they sell the property. So that's where it's important on the trust language about each asset. That's why I ask people, what does money mean to you? And money is nothing more than a tool, but you don't want it to, get your kids into a bind when you make distributions to them.
Yeah. So let's say I have that cabin lease agreement and I've set that up. How do I make sure that that stays in the family forever? Do I then have to fund it? Or can I just say, hey, the taxes are your responsibility, the managing it's your responsibility, but I did a great job and I bought this cabin that I'm just saying is going to stay in the family forever. How do I kind of make sure that those things are taken care of?
Yeah, so let's assume the principal interest is paid, it's free and clear, still have taxes and insurance on the property. So the trust language can shrink wrap, is there going to be reserves or capital reserves held back for the taxes, insurance, and repairs of the property? Is that going to be an expense of the beneficiaries? Because, hey guys, you guys got a beautiful cabin clause in there for nothing. Depends on what the tax insurance on, depends on what the beneficiary's financial status is, depends on the desire for the parents. You can do it anyway.
Okay. And then let's say someone passed away January 1st. How about taxes? How do I navigate that? How long does that take the process to play out? I have a trust. Does that mean I completely avoid all probate? I never have to go to court? How does that process work?
Sure. So taxes are what is it? The only two things you have to do, right, are pay taxes and die. Well, that's kind of true. There's ways to mitigate taxes. And so we deal primarily in estate tax arenas. And so today, just as a brief, 57-second review, today you're allotted about $12 million of unified credit or exemption amount. So husband and a wife, 12 and 12, have $24 million of exemption credit. So in essence, you pass away today, both, boom, boom. So long as your estate is not greater than 24 million and you've used the 706 for portability, your estate will have no estate tax issue. The issue with that is this, and so you might want to keep an eye on, that law is going to sunset in December 31st of 2025, reducing it back to the previous numbers. So you're probably going to look around 6 and 6 million. So, it's a healthy estate. And the reality is that here's where it gets really tricky. You have a $6 million exemption and a $6 million exemption. Husband passes. Wife doesn't do anything, doesn't call the advisors. She then passes, but her estate grew, call it from 6 million, where she would have been safe, to 9 million. Well, she only had that $6 million exemption because nobody filed a 706, an IRS form, to use that unused portion of the husband over to the spouse. If someone did that, took his 6 plus her 6 when she passed away, and she had a $9 million estate, you don't have an estate tax issue. But since nobody got together, nobody connected the dots, she passes away, her estate's at 9 million, but they never did the portability when he passed. You now have a $3 million gap. That $3 million gap of estate tax of 40% is going to cost your kids $1.2 million. For just a simple oversight. Remember what we said at the beginning of this conversation, right? Small hinges swing big doors. That's a very small hinge, but a big door.
Yeah. And let's say, right, we've got this trust set up, or maybe I'm thinking about doing a trust, but the reality is about 50% of people are end up getting divorced these days. I've got kids from a previous marriage, or maybe wife passed away when she was, 40, and I decided to get remarried when I'm older. What are some things and she had previous kids, but I didn't have any more kids. What are some things that you can do in terms of estate planning, trust, titling that can help navigate some of those murky waters?
Prenuptial agreement. So that's, if you're going into a second marriage, third marriage, hell, it's Naples, fourth marriage situation, you're going to want a prenuptial agreement. And if not, then a postnuptial agreement. Postnuptial is a little hard. You're putting the toothpaste back in the tube, not a great bargaining structure. So prenuptial agreement is really what you want to do. Because the whole idea is, and most people enter into that, they're sure there's gold diggers, there's cougars, all that, whatever. The reality is, most people say, and we see this a lot down here in Naples, right? You have a 62 to 72-year-old, right, population demographic that's pretty concentrated. And they were each married maybe divorced, or even one of the spouses passed. Happens all the time. So you have a 68-year-old couple coming in. He has 2 kids, she has 3 kids. That's a very, very delicate situation where you want to make sure that I want to provide for my loved one, but I also want to provide for my kids when I pass. And we call that the pool boy tiki girl kind of planning, because we don't want him to pass away and then she goes with the tiki, well, pool boy, excuse me. But more often than not, it's the tiki girl that we're going to need to really be worried about. And people say, I'll never get remarried. Never is a long time. And so really what you want to do is each have your kind of respective estate plans, saying I'm doing a carve out for this, I want to alter the kids, held in trust. But a prenuptial agreement is really going to help. And a prenuptial agreement is simply this. It's an engaging in a contract between husband and wife before marriage about what happens when I die, what happens if we get divorced. That's it. Just gets a little bit more emotional than that, but yeah, that's it.
Yeah. And if I wanted to kind of after the fact in my trust say, hey, I want these specific assets to go to my children and these specific assets to go to her children prior to marriage, can we all agree upon that and put that into trust? Or what does that look like?
Sure. So a prenuptial agreement is kind of a basement. We're entering into marriage in 6 months. We've agreed upon this as the basement that I will provide for each other, right? 13 years later, I want to give a little bit more. You can either ratify and amend the prenuptial agreement or just add in your trust. I'm carving out a larger sum for my husband or wife. So this is kind of like a defensive basement. This is what we're going to be agreeing upon. I've seen a couple prenuptial agreements come in where it doesn't even talk about death. It just talks about divorce. So once again, going to that specialist about family law or estate plan is really huge, because if you have a prenuptial agreement only talks about call it divorce and nothing about death, it makes it very difficult to do planning, because you can't really disinherit a spouse in Florida, where you can, but they're entitled to what's called the elective share, 30% of the elective share. So at, you know, a minimum, they're going to be getting 30% of that elective estate.
Yeah. So I think that's also just a good point. It depends on what state you're in, right? Wherever you're at, you need to see someone that's licensed and barred in your state.
Yep.
You can't just, go do anything. And then what are some other documents, right? So let's say, right, we've gone through the process now. My parents passed away. They don't have a will. It's all going through probate. I got to contact an attorney, and then we kind of got to fight about it in court. A will, at least they've set instructions, but that will still is going through probate. Still got to contact an attorney to walk that through. The whole process is 9 months. If I don't have, or if I've done my estate planning by naming a beneficiary in all my accounts, it happens quickly. But now the assets aren't protected. If they're subjected to creditor liability, if they're subjected to a divorce or something like that, all those assets are gone. Or sometimes, right, if that person's just, 18, 19, 20 years old, you leave them $1 million, brokerage account, they can go buy a Ferrari, they can go do whatever they want with it. Maybe that's not your goal. So the best plan would maybe do a trust. Now you can put some stipulations on it. You can keep from creditors. You can kind of lay it out there based on how you want it to be distributed. Those are kind of the 3 processes. What other documents do I need in my estate plan to make sure that I have a complete estate plan, not just a will, titling my assets for a trust?
Sure. Think of it like this. Think of 3 columns, right? I am alive and well. I am alive and not well. I am not alive. So only one is guaranteed to not be alive at some point. Some people are born alive and not well, right? Incapacitated, I have special needs, anything like that. So what you want to do is really plan for the alive and well and then alive and not well. So alive and not well meaning incapacitated. A lot of people overlook this and are just hyper focused on the death because someone didn't walk them through the process. But incapacity is a huge issue. I'm sure we could pull out, statistics about the average cost of long-term care, what this looks like. But 73% of statistics are made up, so we won't do that. But you got to look at this: power of attorney. If I am incapacitated, who is able to get on the phone with Sean? Who is able to talk to the IRS? Who is able to pay the tax insurance on the mortgage, right? Or tax insurance on the property. So those powers of attorney are huge for financial incapacity. And then also for medical, looking at healthcare surrogacy, living wills, advanced directives, that basically say, if I'm banged up, here's who I want to make decisions for me, right? Healthcare surrogate, Florida. Versus living will, advanced directive. I today, Ed Smith, say, if at a future event, I'm in a persistent vegetative state with no sense of recovery, then I want withheld and withdrawn certain measures as to not artificially prolong life. That's called an advanced directive. It's a little bit more severe because I'm saying that today. You look at that Terry Schiavo case that actually happened down here in Florida. There was no clarity on those documents, kept her alive till she was skin and bones for argument over family. So that's why, once again, remember, act of love. This is an act of love for your family to know what the hell you want if that really comes into play. Removes a lot of emotion from that.
Yeah, that's great. Awesome. So I think we've got some polling questions, Nora. Is that right?
Yeah, we have some that came in, so I can kind of just jump into those if you guys are good with that. The first one, do partial distributions out of the trust minimize estate tax responsibilities?
Traditionally not, because what you're doing is you're doing a gross estate. So you have your gross estate minus, tax liability, all of that gets you your net estate. So traditionally, it doesn't mitigate any estate tax issue.
And I would also say too, right? Some of the things I think about is, Ed talked about that $25 million amount. What happens, right? If you start gifting away, and right now in 2023, you can give away up to $17,000 per person, and both you and your spouse can do it. So up to $34,000 per year. And you don't have to file a gift tax form when you file your taxes. If you give away more than that, you're more than welcome to. And one of the questions we often get is, if I give away more money, do I have to pay taxes on that? Or do my children have to pay tax on it if I receive it? The answer is no, right? But the math gets a little bit weird. If I give away more than that $17,000 per person, I have to file that gift tax form. And so even if it's in my trust and I start giving away, if I give away more than that $17,000 per person, I'm filing that gift tax form. Every time I give more than 17, we take that number that Ed spoke about, it was 25-ish right now, $1 million estate, and I subtract whatever amount above 17 that I've given, right? So for my individual one, maybe 12 and a half, if I give away more than 17, I'm subtracting whatever I gave away more than 17 off of that 12 and a half. And so every year I have to file that gift tax reform for perpetuity. And when that law changes, as Ed said, when it sunsets there in 2025, and that number goes down, now I'm gonna have to file a gift tax exemption form. It says, hey, I gave away more than this, and now I'm subtracting it from 6 million. So all that amount adds up to what your estate tax liability is, and it gets pretty complicated. That's why we kind of get into this partial distribution while I'm alive, or I start giving money away throughout my lifetime. We always want to be careful, because then we kind of start eroding some of that estate plan. And not a big deal when it's $25 million. There's very few people that have a combined estate with their spouse more than 25 million. But now all of a sudden we talk about 6 million, 12 million. That becomes much more playable. So it's something in the tax law that we're always monitoring moving forward to find out how is that going to change my estate tax liability, or some things that I should do as part of my gifting strategy.
Yep. If you want to be tax efficient, there's a good, what is the line? You got to smoke them if you got them. Use your exemption while you have it to a certain extent. There's tools that you can use today to preserve that, $12.5 million.
Yeah. And oftentimes too, people will say, if I put money in a trust, that saves on taxes, right? A lot of those laws went away, if I'm not correct, right? Used to be able to kind of trust, right? And give money. Now, any income that comes into a trust above $2,500 gets taxed at the highest rate. So we want to kind of mitigate how much money a trust makes. A lot of those rules changed.
Yep.
Okay, thank you. And there's two questions that came in. I'm kind of combine them. So one person asked, what are the types of trusts, Ed? And then the other question got a little bit more specific, which probably get into that one, is, can I designate, a charity? Is there a specific type of trust for that? We kind of mentioned revocable trust, irrevocable trust, things like that. So can you kind of talk about that?
Sure. So there's probably, 27 different trusts that you could use. Traditional foundational estate planning traditionally uses revocable living trusts, meaning you can change the trustees, beneficiaries, amounts, designations. You can sell assets in and out, take it. That's fine. That's kind of what the scope is today. You also have irrevocable trusts. Irrevocable trusts are, as you can probably guess, very difficult, if even possible, to change. But there are different types of irrevocable trusts. Irrevocable trusts can be used for Medicaid planning, called Medicaid Asset Protection Trusts. If someone has a long-term illness and they need to pay for long-term care, how do we use that 5-year look back? That's more of an elder law discussion. But really, there's only three ways to do that. I mean, pay for long-term care, it's private pay long-term care insurance, or Medicaid. Medicaid has strict asset and income requirements. So traditionally, the job is not to put millionaires on Medicaid, but there are situations where you have early onset at 62 that someone's going to need assisted living, skilled nursing, that it might make sense. So it's another type of irrevocable trust. A couple of other ones that we're using today are, spousal estate reduction trusts, CERTs. That basically you gift irrevocably to your spouse with different terms on the trust. And what that does is it preserves, you're using your $12 million exemption today. So that if I give irrevocably an asset to my spouse for $11 million, I've used 11 of my $12 million exemption, but it's held in an irrevocable trust. Now, if those assets appreciate another 5 million when I pass away, those assets are outside of my estate. So really, I've used my 11 million, right? If you want to do 12 million, plus another 4 or 5 million of growth, that's $17 million is outside of my estate that is not subject to estate tax because I use the laws what I have today. So we've been doing a lot of that down here as well. And then what was the rest of the question, Nora?
One just specific to list a type of charity.
Oh, charity. Yep. So charitable deductions are huge. A lot of ways we can do charitable planning are with what's called charitable remainder trusts or charitable lead trusts. Each of those are dependent upon what the market is doing at time. I believe right now a charitable lead trust would be the most advantageous to do. But what you do, you basically fund assets in, charities will be the bottom line beneficiary. And at the end of the day, you're still getting, money back in tax credit on that. There's ways also to make conversions from IRA and retirement accounts directly to charities that would help kind of reduce your adjusted gross income. But charitable trust, charitable lead trust, those are a couple of different ways we can do that. A lot of clients use donor advised funds, DAF, so that they can put money if they don't want to do a charitable entity or they don't want to create a family partnership, so that they can basically direct where this money is going through a donor advised fund.
And if I have a trust and I've got 3 children, can I do, rather than a third, maybe 20 and the 40% of it to a charity?
Sure.
Do I put that in a trust, or I set up my own a separate trust for something like that?
It depends on the the asset structure, but yeah, you can certainly do that. And even if, let's say you got 30 and 10, and you have this charity, maybe it's bifurcated into 5 or 10, have a conversation with your kids, your grandkids, your family about why we're doing this. This is a value that we value. We're giving to the church or this organization, whatever it is. We're doing this not to take money from you, but to show you that this is important to us. And so I think, it's very often people wait to the box to explain things, and then you draw assumptions. Really what you got to do is talk about this stuff with love, with the family, so they know, like, hey, this is why we're doing this. This is huge. We gave back to the institutions that raised you, that helped you, whatever it is.
And then I guess that leads to a point. If I have a trust, do I make sure that just my trustee has a document? Do I make sure that everyone I have in that has a document? Do I just put it in my closet and one day they'll find it? Do I give it to as many people as possible so that the trustee is held accountable? What should I do with my trust after I get it done?
So our firm, as a procedure, generally holds the originals. We will give a paper copy to the client, and then we'll give electronic copy as well. The reason being is we want to make sure we can find it, have it held, do amendments, revisions, whatever it is. You can give copies to your kids depending on how comfortable you feel with that. If you're disinheriting a child, it might be a little touchy to give them that copy. I wouldn't maybe do that. Although, you know what, maybe having that conversation, hey, this is no surprise, probably. Nobody really gets disinherited and is like, wow, I didn't see that coming, right? Usually you can see that. But for the fiduciaries, meaning the personal representative, the trustees, powers of attorney, the healthcare surrogates, you want to make sure that they at least know, hey, this is my attorney's card. Something happens to mom and I, dad and I, call them.
Great, thank you. And this one gets a little specific, but I know a lot of people have come into this, especially with remote work lately. They have asked, we've moved a couple of times across different states. How often do I have to update my will or trust? And before I have you answer that, Ed, Sean, there's a poll question. It'd just be interesting to see if the participants on this webinar, how often they check their will and update their trust. So Sean,
Hey,
if you
I'll fire it up, Nora. This is the first time I've done the poll, so
Ooh,
here it goes. Hopefully you see it now. I believe I've got it up there. We'll leave it up there for a little bit. So, have you reviewed your trust beneficiaries within the past year? Have you reviewed your trust within the past 5 years? And again, I think this is one of the ways that we provide value to our clients, right? We meet with our clients on a quarterly basis. And in the first quarter every year, we have this conversation, right? Has anything changed in your life? Is that middle child? Do you still like them, right? Are they still on your good terms, right? Has someone gotten married that maybe they're having some trouble with? Is there a reason that maybe we need to update our trust? We always go back and look at the accounts. Hey, your beneficiaries are updated. You had a trust created. We reviewed your beneficiaries and your trust is on there. Again, making sure that those things are all reviewed on a regular basis, because most people don't wake up every year or every day and say, you know what, I'm wondering if I reviewed those things. So this polling question is out there. When was the last time you took a look at it? Do you review them on an annual basis for your beneficiaries? And then have you looked at your trust in the last 5 years? At any more specific, like how often should someone look at their estate plan? What are some things that should trigger that conversation with an attorney?
yeah. So there's like a movie, I think it's 4 Funerals and a Wedding or something awful, rom-com 90s. Like in 1 year, you can have a lot of different events that are going to blow up your estate plan. In 5 years, you might not have anything that occurs. So really what we say is life events, not really years, right? It's kind of like dog years. It's more life events. Because did someone get divorced? Does someone have a creditor issue? How's your marriage? Did you acquire an asset? Did you sell a business? Did someone pass away? Did you inherit property, right? Those are the things that are going to tweak. And did you move to a different state, right? Those are the items that could affect materially your estate plan, not years as much.
So this is good, right? The benefit, have you reviewed your beneficiaries within the past year? 45% of people say yes, 55% of people say no. Have you reviewed your trust within the past 5 years? 9% of the people say yes, and 91% say no. So pretty interesting to see how often people are reviewing those things.
I am the cobbler's son with no shoes. I have not reviewed my trust in 5 years. So I'm going to be doing that. It's important though, right? I mean, it really is, and most of the documents are drafted for kids and generation, but it's important to do. And I saw just one brief question. If I'm not wealthy, should I have an estate plan? I just want to tackle that. Yes, 100%. Absolutely. It's not about money. It really is not. It might be the only one thing in the world that's not about money, even though it's really encompassed with money. Because it's really, I don't care if you got $1,000 or 20 million. Where do you want your assets to go when you pass away? How do we do it in an effective strategy, right? And then more equally importantly, if you become incapacitated and you don't have anything in place, you're now looking at a guardianship, right? If you don't have documents saying who's going to make decisions if I'm incapacitated, now you're forcing your family to then go to the courts to get a guardianship over you because there's no legal document indicating who's going to do what by when. And so that costs 15 grand a year, something like that. And now basically you're a ward of the state and you have a guardian on that. So that's why those incapacity documents are huge. So absolutely, if you're not wealthy, that matters not.
Okay, and then Sean and Ed, we talked a little bit about how to fund a trust and how important it is, not just to have the documents, but to actually fund the trust. Can you lay out some examples? I know we obviously have investment accounts, but what other things should we be thinking about that we need to add, a transfer in death or something like that for the trust?
Are you asking me, Nora?
But both of you guys. So I know from our standpoint, obviously investment accounts, and we talk to clients and we want to make sure that the beneficiaries are the trust or the spouse and retirement accounts. But Ed, what other things, what other type of, assets would you say should be funded by the trust?
Sure. So pretty much the vast majority of your assets, depending on case-specific scenarios, should be funded into the trust, assuming that it is tax efficient and assuming that it achieves your goals. Because remember, if we harken back to 53 minutes ago, everything in Florida is going to go through probate, unless number one is jointly owned, Number 2, it's beneficiary designated or PANDA. Or number 3, it's funded in the trust. So you want to have kind of belt and suspenders on that too. Because as soon as you have a jointly held property that one passes, it's not jointly owned. Fund that into the trust. As soon as you have a beneficiary designation asset that goes to the beneficiary, maybe there's no successor beneficiary. So you're going to want to either fund that in the trust or have a backup on that. So like bank accounts, checking, savings, business interests, real estate. You have an LLC or a corporation, you want to assign those interests. You want to have business formation documents, operating agreements for all of that. And so, because if anything's out in the wind, it might be fall subject to probate, which is not, once again, it's not fatal. It's just going to take a little bit more time and money. So we want to mitigate probate to the best of our ability.
Yeah, I think some things too, Nora, like, and again, it depends on state, right? But, cars, right? Again, just every asset that you own should be in there. And then I think too, some things that are important are like specific bequests, right? If I've got a gun collection, I want that to go to, my daughter, or if I have a wedding dress or a wedding ring and I want that to go to a specific daughter, or, right? You want to mitigate some of those fights that will happen down the line that, right, inevitably happen, right? Whether or not you want to happen, you want to make sure that, as Ed said, estate planning is about love. You want to make sure that you keep the love in the family, because kids could end up fighting over certain things, certain properties, certain investments. If you haven't gone and laid it out and you think, yeah, it'll all be all right, they'll get it, they'll be happy. It's better than, them having nothing, right? Which is maybe what happened to me when my parents passed away. I didn't get anything. The kids will be fine, but it ends up ruining their relationship, right? Because they start going after your things, and that was not your intent. You were like, I just thought they'd get something, and that's better than getting nothing. But it ends up ruining their relationship as they fight about it. So if you are able to have the conversation with them, right? If you're able to get a proper estate plan in place and communicate that to them effectively, then maybe you can preserve some of that love in your family, which is probably your ultimate goal after you pass, is make sure that the family's still together.
Yep. And using a separate writing memo, basically that you can walk through the house and tangibly write who gets what and how, whether the gun collection, family Bible, wedding dress, that's huge. Give gifts during your life. I mean, I encourage clients, you got all this beautiful jewelry, it's sitting in a box, like give it to the granddaughter, like say, this is, I want you to have this. Inter vivos gifts, what those called, so long as it's not the Hope Diamond, you don't want to be reducing your estate and gift tax issue. But, those are things that you can be doing now when you're alive and well.
Great. Thanks, Ed. Thanks, Sean. That's all the questions that came in. I'll continue to check Facebook Live for comments as well. But really appreciate all your comments, your information, all the education, Ed and Sean. Sean, any kind of closing thing that you want to mention?
No, I think it's important, right? You got to have a partner with someone like Ed that goes through those things, does them for you. Have those conversations with your family, and ultimately, right, if you're going to do this or have a financial advisor, work with someone that's also taking a look at your estate plan, someone that's going to look at your life holistically, and build the right team, right? You want to be able for your advisor and your estate attorney and your accountant to all talk together so that, right, everyone is on the same page and everyone knows what your wishes are. Everyone knows where you're at in your family life, because the estate attorney may say, yeah, well, this is kind of what we did. And then you're like, well, as their financial planner, I know that there's some things going on with one of their children. Did they bring that up? Did they talk about that? And like, no, maybe I'll reach out to them and make sure. And they didn't think about those things, right? So build the proper team and work with an advisor that's going to meet with you and talk about more things than just your investments. And then when you do, work with an estate attorney that does estate attorney, right? As Ed mentioned, someone that's trained in that specific area. They do criminal defense. They're probably great at the criminal defense, but maybe they haven't done estate planning in a while and are not up to date, current with all those things. So work with someone like Ed. And then again, this is educational, not meant to be instructional or legal or financial advice. So meet with the proper team on your own terms, take some of this information to ask the right questions. Ed, anything else that you want to kind of add as we close up here?
Happy to be here. Thanks, guys. Great opportunity, and best of luck to all of you.
Awesome. Thanks, everyone. Enjoy the rest of your week.
See you guys.